Welcome to the AJLS panel. We have attained the quorum and now call the meeting to order. First of all, members may wish to refer to the papers tabled for members. On the 14th of November, the Vice Chairman and myself did talk with the administration regarding the scheduled and meetings for the year 2013 to 14, and also the issues to be followed up. And for this term, please refer to paper CB4 181/12 to 13 bracket 01. There is a checklist there for members' reference. In terms of the schedule, we did consider the period of the first half of 2013. Like mediation, the government has proposed a timetable. And in the paper bracket 02, there are certain items for which we cannot confirm the timing until the Law Society has given us some indications. So there is some flexibility, and there can be flexibility regarding the items to be put on the agenda for discussion. Are any comments on the list of outstanding items? Vice Chair. I wrote to the HAB regarding the legal aid for criminal cases. Towards the end of this year or next year, there will be a review. Normally, this will be put back to the panel for discussion. Item 15 has to do with the supplementary legal aid. I'm not sure whether, Madam Chair, we should include the legal aid for criminal cases, or should we set up a specific item on this particular issue. Right? Other members, any comments? Ms. Emily Lau. Madam Chair, if this is under the HAB, I think we might wish to subsume this under this item, unless they have a timing problem. Unless members have any comments, I am also of the view that since we are talking about legal aid anyway, we can put them all together under one particular umbrella. So the legal aid for criminal cases will be put under 15 as well. Anything else on the outstanding items? If not, the next meeting is scheduled for the 14th of December. We have advanced the meeting to a Friday to 10:45 because it is close to Christmas. And there are a couple of items that we have checked with the administration. The first one is the Law Reform Commission's consultation paper on rape and other non-consensual sexual offences, and they are ready with this. The second one is the information technology infrastructure for West Kowloon Law Courts building, and they are ready on this one also. The third one is the proposed amendments to the arbitration ordinance. In particular, they are reaching the advanced stage with regard to consultation or discussion with Macau SAR regarding the mutual arrangement. So we will put this on the agenda for the meeting scheduled for December the 14th. The administration will bring us up to date on the situation. So I'd like to hear what members have to say in this regard. All right, then, unless you have any comments, I'd like to add another one on the 19th of October, I've made available the information pack from the International Arbitration Center, the ICC, and in relation to the appointment of arbitrators and mediators, there are some principles there in terms of appointment. We thought about circulating the paper, but I mean, it is a very copious paper, and they respect the views of panel members, and they would very much like to hear from members' comments in this regard. So I'm wondering whether we can set aside a bit of time for discussion of this item. So I'm all ears. Or are you happy with a circulation of the paper? And if members are interested, they're welcome to submit their views. Which one is the preferred option? Circulation of paper or what? If you prefer just the circulation of paper, then we so decide. Those who are concerned about the principles regarding arbitration, you're welcome to air your views, and we will make onward submission to the Arbitration Center. All right, then, unless you have any further views, let's move on to the item 3 of the agenda. We'll invite the DOJ representatives into the conference room. That's paper CB4 1721/12-13 bracket 01. That's in relation to the relocation of the DOJ to the former central government offices, Main Wing and East Wing. And they'd like to take up about 10 minutes of our time with a PowerPoint presentation. We'll be inviting Mr. Arthur Ho to brief us. Are you ready? Right, then we should maximize the time available. I'd like to defer to Mr. Arthur Ho. Madam Chair, there is a PowerPoint presentation by the ASD. Perhaps I'd like to say something. In 2009-10 policy address, it was pointed out that when the CGO has been moved to Tamar, the Main Wing and East Wing of the former CGO will be kept for the DOJ, and this is intended to put together all the officers scattered at different places for operational efficiency. When upon relocation to the CGO Main and East Wings, most of our officers will be concentrated there, but because of the space constraint, there will be some officers, including the prosecution division, that will remain in QGO. The building was built in the 1950s. It has historical value, so we have taken measures to minimize all the impacts that will arise on the buildings. We have conducted an HIA, Heritage Impact Assessment, the AAB, on the 14th of this month has considered this particular case. We will make sure that all the recommendations will be followed through in the course of renovation. With the funding approval by the FC, we anticipate that work will get underway in the second quarter of 2013 for completion in 2015. With your indulgence, Madam Chair, I defer to the ASD. Yes, ASD, please. Madam Chair. I'd like to use PowerPoint to brief members on the relocation of the DOJ to CGO Ming and East Wings, and we will brief members on the background, the project, and Also, since there is heritage consideration, we'll touch on that. We'll also touch on the schedule.
Now, background. The project was mentioned in the 2009-2010 policy address that the main and east wing of the CGO with historical value will be preserved. And when the bureaus have been relocated to the new CGOs, the DOJ will move in the main and east wings of the CGO. So several points to note. First of all, the scope of works in relation to the main wing and the east wing, and the red line shows the demarcation of the works area. And part of the works have to do with the preservation and repair of existing building structure. And one of the main points is that we'll try to preserve the original facade and the appearance of the building. And this is the artist's impression and the perspective drawing on how we're going to preserve these elements. And one area of the works is that for the exterior structure of the building, including the plant rooms and the service ducting, they will be replaced and they will be moved inward to have a better appearance. Whereas for the remaining exterior structure of the building, they will be kept as far as possible. And some of the original layout will be restored. For example, window-type air conditioners. They will be removed to reduce the visual impact. And the new steel windows will also be installed that match the original design. As for the roof, we do not just treat it as one of the sides of the building, we treat it as the fifth dimension, and we hope that some roofing works will be done, and this will be done through some greening works, and the service ducting, etc., will be covered so as to minimize the visual impact on the exterior of the building. And through roof greening, we hope to improve vista, and non-reflective solar panel will be installed to enhance green space and promote efficiency of energy. And the other point is to carry out internal office layout restructuring and functional improvement. This is the internal building plan, and we're going to do some restructuring to enhance the functional improvements. And the facilities include offices, libraries, conference rooms, and a multi-purpose room, etc. As we have to carry out the works, we note that some of the floors are not accessible by lifts, so we are going to reconstruct the lifts and add new lifts so that all floors can be accessed and served by lifts. As for internal decoration, the steel windows, as we said, have been in place for many years. In terms of acoustics and heat insulation, they cannot meet the current standards for government buildings. So where necessary, we're going to install aluminum windows which can improve acoustics and the indoor environment. And this will also help improve the indoor environment. And there are also enhancement works for complying with statutory requirements. For example, staircases will be provided on certain floors in order to provide an escape routes in that comply with statutory requirements. On the other hand, we'll try to install barrier-free access facilities as an improvement measure so that this building can become a barrier-free building. Heritage considerations. As said just now, we have also made effort in this regard. Now, in the 50s, this picture depicts the appearance of the east and the main wings of the CGO, and through decades there have been considerable changes. For this part in pink or orange, in 1989, these parts were removed and the new annex building was built. And in the 1990s, the former Executive Council chamber was built. And a consultation had been conducted with the Antiquities Advisory Board. Some recommendations had been put forward, and these recommendations have been endorsed by the AAB. And this slide shows the number of recommended works to be done for heritage conservation. And from ground floor to the first floor, there are also works to be carried out for heritage conservation. And some conservation works will be carried out on the exterior. And for the metal fence along the boundary along the Lower Albert Road, according to the HIA report, the fence along the main wing and the east wing should be replaced by a lower fence with compatible design. And we have adopted this direction and included this as part of our project. On the north side, for the metal fence, for public safety reason, this will be preserved. And we also explained to the AAB, and we got their support. And after the explaining about the fence on the south and the north side, on the west side, originally we do not have any metal fence, and we're going to increase the greenery area so as to increase green space. This is the view showing you the greenery areas after the works have been completed. There are also valuable trees within the area, and as far as possible during the planning and design and the heritage conservation, we'll try to preserve these valuable trees and increase greenery areas. Next, I'll come to talk about the project program. As I said, in June 2012, we submitted the design, in particular the heritage conservation part, to the AAB, and they endorsed our report. And in July 2012, we consulted the Central and Western District Council, and we also received their support. And in January and February 2013, we're going to submit the proposal to Public Works Subcommittee and the Finance Committee for funding approval. And subject to the approval from these two committees, we expect works to commence in the second quarter of 2013 for completion in the first quarter of 2015. So much for my presentation. Thank you. Okay, the floor will be open to questions. The first member who has raised her hand, Ms. Emily Lau. Let's see how many members are also interested in this item. Mr. Paul Chair, Mr. Yu Si Wing. So 3 minutes each. We'll see if it's all right, because we're talking about so much money, 700 million. Chairman, basically, I do not have any view on the relocation. But I know that even after the office is relocated, it's still short of space. Now, Chairman, you know that for the West Wing, negotiation is still underway, and I know that the government officials may not be able to give an answer today. If the West Wing is also kept, then space can also be allocated to the department so as to have to keep the offices intact. Now, one of the points is that the original external appearance will be preserved. But in fact, before 1997, there was no metal fence at all, and I had never heard of any public safety issue. And Mr. Tong Shi Hua decided to build metal fence, And why they seem to me that the government was so afraid of the public. In fact, all metal fence should be removed, but according to the presentation, some of the metal fence would be kept. Well, in order to preserve the original outlook, shouldn't all be removed? Now, the other point is about barrier-free access. You're going to anticipate more questions in the future when you submit papers. Is it the case that you have to comply in full the statutory requirements, or are there any other reasons? The other point is the ladies' toilet. I really have this feeling. We have been talking about this issue for many decades, and more female staff would be stationed there. We're seeing more and more female councils. So this should be standardized. Every time you submit papers to LegCo, when we talk about greening measures, we are in all support. But things like barrier-free access facilities, well, in fact, Mr. Lam Wun Kwong also says that it's sort of outdated. It shouldn't be called barrier-free access facilities anyway. So please answer the several parts of my question, Mr. Ho. Now, about West Wing of the CGO, the administration is still considering the future arrangements for the West Wing, and in the course, public's views will be taken into consideration. So this question should be directed to the Development Bureau. I will defer to my other colleagues to supplement on the arrangement. Now, our thinking is that if metal fence is not necessary within the main and east wings of the CGO, they can be done away with. Now, for the metal fence along the slope, in the future, the metal fence can be removed so that the public can have access to the main entrance of the DOJ's office. As for the metal fence to be kept or to be replaced by lower fence, this is because the ground floor of the building is higher than the pavement by 1 or 2 meters, and for public safety reason, the metal fence will either be kept or be replaced by lower fence. It is only due to this reason that the fence is kept. And like I said, the public will have access to the DOJ's office in the main wing. As for barrier-free access, I'll defer to my colleagues in the ASD. Now, metal fence, if there are further questions, Madam Chair, please invite the representatives to speak into the microphones because I am somewhat deaf. I really can't hear you. Please speak into the microphone. Members. Now, about metal fence, for safety reasons, it will be kept. And at certain spots where possible, the fence will be replaced by lower fence. Just like in this picture, along Lower Albert Road, there is a stone wall, and it is quite high. So a low metal fence is necessary to prevent someone from falling off from there. And this will be replaced by a lower fence. And in the assessment report, you can see that there were signs of metal fence previously erected. So we're going to erect low fence at that place. And for this point at the back, facing St. John's Cathedral, the slope is as high as 3 meters tall. So we suggest that the metal fence should be kept at this height. As for the other side, facing the west wing, there is no metal fence. As for other spots where metal fence was erected before 1997, these spots were outside the works area in this project. As for barrier-free access facilities, in this project, for the main and east wings of CGO, we are going to abide by the existing standards applicable to barrier-free access facilities and install them accordingly. Okay, I'll allow a second member to ask questions first. You can ask a follow-up question later. Madam Chair, please ask her to answer the question on toilets. We are complying with the ratio requirements under the Buildings Ordinance. We're going to install toilets accordingly. That's in relation to the number and the toilets for disabled. Mr. Paul Chair. Now, according to para 3, 4, and 5 of the paper, for offices outside the QGO, including the ones in United Centre, Admiralty Centre, and Harcourt House, the total area is about 4,700 square meters. But if it's moved to the CGO, then total usable floor area is 11,170 square meters. That's a jump of 4,670 square meters. So have you considered whether there is any such need for expansion? As for the prosecution's division, they will stay at the QGO. I believe that it's for the convenience of access to the High Court. If in the future the West Wing will be indeed be kept, will you consider relocating the prosecution's division to the West Wing for this purpose?
Mr. Ho? The CGO East and West Wing, Main and East Wings comprise 11,100 square meters, and the DOJ has a floor space of 17,000 square meters. So CGO Main and East Wings will not be sufficient to accommodate the DOJ in its entirety. So some officers will have to be kept in Admiralty. We'd like to keep these officers in the QGO in Admiralty. In relation to West Wings, West Wing, will the DOJ be accommodated in West Wing? The government is looking into this arrangement. No decision has been taken yet, and we're not sure how the decision is going to be like eventually, but certainly we will relay a members' views to the Development Bureau. Mr. Paul J. That the QGO, what is the floor space like at the moment, and what is the floor space that will be kept in QGO? Mr. Ho, now for the officers in QGO and other, the floor space is 11,700. For CGO Main and East Wings, it is 11,100 square meters, so it is not enough to accommodate all the DOJ officers. Right, will this be considered? And next, Mr. Yu Shiwing. Madam Chair. So the floor space will be smaller, not double. It's going to be 11,000. At the moment, it is 14,000 square meters. So if you take CGO Main and East Wings together, will there be more floor space or less for DOJ? Mr. Ho. Now for CGO Main and East Wings, West Wing, we're not sure about the fate going forward. So we're going to use CGO Main and East Wings. The area is 11,100 square meters, 11,100. Now the DOJ has offices in Admiralty. Altogether, we are talking about 17,700 square meters. So CGO main and east wings will not be sufficient to accommodate all the DOJ officers. So upon relocation to CGO main and east wings, some officers will still have to be kept in QGO. Mr. Yu, we don't want to see the officers scattered all over the place, and if you run out of space, you will still have to add additional spaces. So we hope that we will be able to have an office which will cater for the development in the coming 5 to 10 years. The paper is not sufficiently clear. You talk about the CGO main and east wings. I think you have to make it clearer for us. With the expenditure, we're worried that the space will still not be sufficient. With the non-reflective solar panels, how much electricity supply can be met for CGO main and east wings? What percentage of the electricity supply can be met by the solar panels? I mean, it doesn't make sense if just putting them there just for the sake of it. Mr. Ho? But for officers that will not be accommodated in CGO, they will be concentrated in QGO for better operational efficiency. We are discussing with the GPA as to how the officers can be accommodated in the QGO. So most of the officers of the DOJ will be located at CGO main and east wings, and the others will be in QGO. There are going to be 2 places. For the solar panels, I defer to the ASD. Honourable members, we mentioned a moment ago that there will be energy-saving facilities, some renewable energy facilities. Through these facilities, we hope that we will be able to achieve around about 10% of the electricity. All right, Mr. Michael Tin raised his hand for the first round. Second round, Mr. Emily Lau and Mr. Paul Che. Any other members who would like to have a go at this item? If not, we aim to bring this paper to an end on time. Mr. Michael Tin, Madam Chair. Mr. Paul Che talked about the West Wing. I know that there is no plan for the time being. What is the floor space for West Wing? Will it be able to make up for the shortfall upon relocation to the CGO main and east wings? Now you are soliciting $800 million. That's a really staggering sum of money. Is it because you have to measure up to the new building code? And for old buildings, they don't have to measure up to the building code. Is that correct? Is it? Of these $800 million, how much of it has to be spent, or how much of it would be needed to measure up to the new building code in terms of fire safety, fire escape, and so on? What is the difference between the 2 sums, Mr. Ho? Two questions about the West Wing. The West Wing, the administration is still considering it at the moment. We're not sure about the fate, so the DOJ doesn't have any idea about the exact floor space. As regards the building costs, I appreciate Mr. Michael Tin's point. We'd like to be as cost efficient as possible in this regard. Now, we do have to measure up to the legislative provisions. We have to provide the barrier-free access, and we have to restore the buildings to the original state. As to the breakdown of the building costs, perhaps I defer to Ms. Lam. Members, the tendering process is still ongoing. We still have to collate the data. At the Public Works Subcommittee, we will make a report to members. In response to Mr. Michael Tin's question, I can say roughly that there are 2 things that add to the cost. The heritage preservation, and also we have to bring the building in compliance with the fire installation regulation, the fire escape, and the building ordinance requirements. In terms of renovation cost, a ballpark figure would be something like a 20% in addition, but all the details will be supplied at the PWSC. So $160 million will be needed to bring the building in line with the present-day requirements, but under the law, you don't have to spend the money, do you? Ms. Lam. Well, we don't have to follow this procedurally, but when it comes to these public works, we have to comply with the legislative requirements, and that's the standard we observe. Mr. Raymond Wong raised his hand for the first round. Perhaps we fit in Mr. Wong first before we move on to the second round. Beg your pardon, Madam Chair. Well, I had a fight with a judge a moment ago. I've got some comments to make here. I've got them written down. And I look forward to a response from members. Now, regarding the justifications, I'm not sure if this has been covered or not. If I am repeating the points, please give me a shout. Now, in relation to the justifications, paragraph 5, for the QGO, it is 13,000 square meters. They're scattered in the outstation office in the vicinity of Admiralty is about 4,700. The CGO main east wings and the floor space is 11,100 square meters. There is no information regarding the QGO floor space. We cannot determine whether the floor space is going to be higher or lower, and also the extent of change. We get the feeling that the DOJ is expanding in size. If it is expanding, then it is flying in the face of small government, and that's ideology. You don't have to answer this. With an ever-expanding DOJ, I would share Mr. Leung Kwok-hong's concern about the problem. I've been prosecuted a couple of times, and this is a waste of resources. Now, you are prosecuting people willy-nilly, and Mr. Albert Chan, I had a fight with the judge today with the judge. Now, why doesn't the government, in relation to 4,700 square meter offices in private building, why doesn't the government move them all to the government buildings? And this will also minimize the impacts arising from relocation. You can also set aside more space for other government departments. I'm sure that other government departments are also suffering from a shortfall in office space. Or can you keep the entire DOJ in QGO and move other departments to the CGO? I think that will facilitate the communications and also shared use of the facilities of the DOJ. QGO is closer to the law court. The QGO is closer to the LegCo. All the three powers are located in Admiralty. And in paragraph 5, in relation to the rental saving, if you move these offices in private buildings to government buildings, you don't have to pay rent, but government offices will also involve a premium. If the government rent out these government buildings, you still get the commercial rental. You don't have to go round and round in a circle like this. Well, Mr. Wong mentioned some new points. Perhaps the director might wish to respond. Madam Chair. In relation to the justification for relocation and the savings achieved by the administration, the CGO Ming and East Wings are lying vacant at the moment. The government has to consider how best we can use the space. In 0910 policy address, the government said that DOJ is an important government department. For it to be moved to this historical building is a right move. Now, DOJ has offices scattered in many different commercial buildings. We have most of them in QGO, but others are scattered in commercial buildings. If we can move them to the CGO Ming and East Wings and others in QGO, they will be in two places instead of all over the place, and that would enhance operational efficiency. For those that in QGO, they are the prosecution division, and they're close to the High Court. It would be convenient operationally for them to be located in QGO, and this is a good arrangement in terms of efficiency. If upon relocation to CGO Ming and East Wings, the offices in rental premises can be moved back to the QGO, and each year we can achieve rental savings. And this would achieve efficiency. So this relocation to CGO Ming and East Wings is an appropriate arrangement.
Second round, we have Ms. Emily Lau, Mr. Paul Chair. For the second round, try to confine to 2 minutes. Madam Chair, the Director still hasn't answered this question. Is the DOJ expanding? We talk about the future office space. Now altogether is 17,000 square meters, but not all of the offices will be relocated to CGO. So can you tell us how much space is involved? How much space will be relocated? Now, according to Para 4 and Para 5, not all the offices will be relocated. So how much floor space are we talking about? Is it still an expansion? Director, in terms of figures for CGO Main and East Wings, you don't have to repeat yourselves for the 8th time. I just want to say that close to 10,000 square meters will be relocated. Madam Chair, that's why he hasn't told us this in his answer. So only 1,107 square meters. Now, why do we need around 10,000 square meters? Because we need to preserve space. Say, for example, in the main wing, some space will be kept, for example, the conference room, and this cannot be used for office space. And some space will have to be reserved to accommodate certain facilities. And there will be a slight expansion, for example, just several hundred square meters. So in terms of increase in office space, it's minimal. For the remaining offices, around 8,000 square meters cannot be moved. And this will remain in QGO, and we're actually discussing with the QGO and whether more space can be reserved for future operational need, because we have been stationed in QGO since 1986, and throughout the years there hasn't been any room for expansion, and our colleagues are actually very crowded in the office. So we are asking for a slight relaxation so that we have more space and to accommodate future operational needs. So we are asking for a slight increase in the space in QGO in the future, but we're still discussing with the QGO. Madam Chair, when they submit proposals to the subcommittees and the FC, I hope that all figures will be set out very clearly, because members are concerned whether you make use of this opportunity to expand your office. So you have to restrain yourself. You have to set out all the figures. Don't provide the figures in dribs and drabs, because we are against over-expansion. Mr. Paul Chair. Madam Chair, I'm also concerned about this. I really got confused. Just now, some questions have been asked. I'd like to know for the remaining 13,000 square meters or so in the QGO, they won't be released. They will still be occupied by the DOJ. So 17,000 square meters minus 4,700 square meters, this will become the office space for DOJ in the future. Now, the overall area will be increased slightly. Like I said, we're asking for a slight increase so that more room can be provided for our colleagues, but we're discussing with the QGO. But we will try our best to restrain ourselves. We will not use the office space indiscriminately to expand our department. Thank you, Director. I think you've noted the concerns of many of our members on the possible overexpansion and the use of West Wing. I think that you should give a detailed reply, and since the proposals will be submitted to the PWSC and the FC anyway. The proposals will be submitted to the PWSC and the FC in January and February next year. And we can follow up on the issues raised today on those occasions. So I think so much for this agenda item. We'll move on to the fourth item. So thank you, Director. Please invite the DOJ representatives and the representatives of the Bar Association and Law Society in. All right, moving on to agenda item 4. Let me, in passing, report to members that on the 8th of November, as chairman of the panel, having heard members' views, I formally wrote to the Secretary for Justice, Ms. Elsie Leung, and the representatives of the two legal professional bodies to invite them to attend this meeting and give their views. I hope that ample time will be reserved for discussion today. So let me welcome Mr. Rimsky-Yuen, Secretary for Justice, and the representatives and other representatives. We received a reply from Ms. Elsie Leung. She has declined the offer to attend the meeting. Instead, she has provided a written reply, which is a written reply to our invitation for her to attend the meeting to discuss the issue. That's paper number CB bracket 4180/1213 bracket 01. And we've also prepared a Chinese translation, which has been perused by her and which is for members' reference and discussion today. And Secretary for Justice Mr. Rimsky-Yuen has agreed to attend, and he's here, and the letter or the paper concerned is CB bracket 4181/1213 bracket 02. And let me welcome Chairman of the Hong Kong Bar Association and representatives of the Law Society of Hong Kong, Mr. Thomas So, and also Mr. Ramanathan. And they will be speaking on behalf of the bodies that they're representing on the remarks made by Ms. Elsie Leung at the public forum on the 6th of October 2012. So may I first invite Mr. Rimsky-Yuen, Secretary for Justice, to say something on this issue and to express the views on behalf of the DOJ. Mr. Yuen. Thank you, Madam Chair. For the remarks made by Ms. Elsie Leung at a seminar on the 6th of October 2012 and the public discussion arising, the administration has submitted the paper and we will not repeat the stance taken in the paper. I just need to take this opportunity to reiterate our position. First of all, the basic law clearly stipulates the rule of law and judicial independence, including the final adjudication of the Court of Final Appeal in Hong Kong. Hong Kong's people's freedom of speech and freedom of expression are also safeguarded by the basic law and the relevant laws. Since reunification 15 years ago, the Hong Kong common law legal system has been continued in a smooth manner. And under the basic law framework, our laws, including the common law and legislation, have been developing with time. One of the obvious examples is the civil justice reform launched recently by the judiciary. And 2 weeks ago, the prosecutions division of the DOJ also held a major legal seminar to look into the criminal law and the relevant reform in relation to the criminal justice process. One country, two systems is undeniably a new direction on the implementation of one country, two systems and the legal issues arising from it have to be considered in detail. And for the diverse views and even conflicts arising from it is understandable, and it can be anticipated. In handling disputes in relation to the basic law, due recognition has been given to the difference between the legal systems in Hong Kong and the PRC. Now, on the legal system and the basic law, different personnel recently have expressed different views, and there have been discussions in the community stemming from it. It's understandable that different people may have different understanding of the issue. We hope that discussion can be held in a reasonable, rational basis so as to prevent polarization or political bickering in the community. Finally, on behalf of the SAR government will be committed in upholding the rule of law and judicial independence, and to ensure that the SAR government can continue to perform its role by upholding the principles of judicial independence and the rule of law. And we should have confidence in the judicial officers and judges in Hong Kong, and to give due recognition to their contributions to Hong Kong. Secretary, can you give us your speaking notes so that our members can ask questions on your notes? Well, there are still some outstanding amendments, so can I provide the notes later this evening? Please try your best to provide us a photocopy. Sorry, the speaker is off mic. Mr. Leung Kwok-hong. Now let's make good use of the time. Many members are interested in asking questions. So if you want to ask questions, members, please raise your hands. I will invite the two representatives from Law Society and the Bar Association to speak first, and then I'll look at how many members would like to ask questions. So, Mr. Ramanathan, Chairman of the Hong Kong Bar Association, will be addressing us on the remarks made by Ms. Elsie Leung.
Thank you, Madam Chairman and members of the panel. I think you have before you the two position statements made earlier by the Bar, as well as a statement for the assistance of this panel, which was filed last week. I don't wish to expand too much from what is stated there. As the Secretary has mentioned, this matter has raised a considerable interest and debate in the community, and it's not surprising it does so. The Hong Kong Bar recognizes that people should be entitled to exercise their right to express their views, but with that right comes, as we perceive it, responsibility. And that responsibility is even higher when you look at the position and status of the person who utters any of those statements, because it tends to carry the weight of the office of the person who's expressing those views. We do not take a stand that people in high positions should not be able to speak out on issues of importance. But one's got to be careful what is it that one is talking about, particularly in the context of the rather interesting phase we are going through in our development of constitutional history since the reunification in 1997. We've made in our position paper certain fundamental principles which we think are worth emphasizing and reiterating. I don't wish to read them through, but I think the underlying principle, which is a common thread running through that, is basically this: that the basic law recognizes the Hong Kong legal system, the Hong Kong way of life is different from the life and the legal system in mainland, and that is enshrined in our constitutional document. And that recognition goes further in terms of the judiciary to ensure that they are able to adjudicate on issues within the autonomy granted to the HKSAR. So when people or individuals or institutions wish to insinuate that independence is not there, or that power of adjudication is somehow removed because of their different perception of the issue, we have to be careful about this, because this could be the slippery road under which the rule of law could be undermined. And we as citizens and legislators have to be on the lookout for statements like these, which can cause considerable concern. I don't wish to take the matter much further than what we've said here. We have always subscribed to the view that the NPCSC has the power to interpret the basic law. This is a viewpoint which has been shared by the judiciary in going right up to the Court of Final Appeal, and it's a position that the Hong Kong Bar has taken all along. And I think it's a view which is also shared by the Secretary and his department. So for anyone to insinuate that we are looking at it from a position that we do not recognize that power or that right is completely misconceived and wrong, and gives a misleading picture to the public. We've always recognized that, and so have the courts. To suggest that the courts don't understand that, again with respect, is not, if I may put it, a polite way of dealing with the matter. So to end, in conclusion, Madam Chairman, members, we take the view that our Hong Kong judiciary has withstood various pressures and tensions in the last 15 years, and given the quality, integrity, and sincerity of the judges we have, and we are lucky to have them on board in our judiciary, we see that the future going forward, turbulent and difficult as it may be, is such that the challenges can be met by the judiciary and by the people of Hong Kong. Just one moment.
Thanks very much, Mr. Ramanathan. Mr. Shi, anything to add? No, Madam Chair. I'd like to invite Mr. So from the Law Society, Mr. Thomas So. On the 10th of October, in relation to Ms. Elsie Leung's remarks, the Law Society has already made a statement. On the 27th, this morning or yesterday, we have issued a statement, a position statement to the panel. In our Law Society statement on the 10th of October, it is very straightforward. Now, we recognize the importance of judicial independence in relation to interpretation, in particular the mainland mothers giving birth in Hong Kong. The in particular in relation to interpretation of the Basic Law. We do have the established mechanism, but if we seek interpretation on this particular issue, then it would undermine the rule of law in Hong Kong and also the standing of the Court of Final Appeal. And this is in our statement on the 10th of October. On the 11th of October, Ms. Elsie Leung made a response. She has also written to the Law Society and the Bar Association. In our position paper, we'd like to state 3 points. First of all, we respect fully freedom of expression, and that is an expression that is a right enjoyed also by Ms. Elsie Leung. This is enshrined in the Basic Law. Ms. Elsie Leung is the Deputy Director of the Basic Law Committee. Given this background for Ms. Leung to talk about interpretation, it would inevitably give rise to public concerns as to whether what she said represented the Basic Law Committee's views or the NPCSC's views. Under the Basic Law, prior to interpretation of the Basic Law Committee has to be consulted, so that it may give rise to public perception or speculation that what she said to a certain extent represented the views of the Basic Law Committee or the NPCSC. Now, this public speculation has been very rife, and the Law Society decided that we do need to repeat our statement issued on the 10th of October. Thanks very much, Mr. Thomas So. The position paper of the Law Society was or has been tabled in front of members. If you don't have them, please raise your hand. We can issue them to you. We have a lot of members who would like to air their views. Perhaps for the first round, we restrict to 3 minutes for each member. Leung Kwok Hong, Dennis Kwok, Ronnie Tong, Alan Leung, Emily Lau, Tam Yu Zhong, Martin Liao, Starry Lee, and Ng Leung Sing. And lastly, last but not least, Paul Che. Mr. Leung Kwok Hong, 3 minutes, please. Madam Chair, Ms. Elsie Leung is a nice person. She's a very honest, nice person. I respect her honesty. Now, in relation to the Sally Orr's case, she was very honest, and she disclosed the reasons. And she mentioned Article 23 as a sort of demarcation. I mean, she's a very straightforward person. Under Article 158 of the Basic Law, the right of interpretation lies with the NPCSC, and the NPCSC has to consult the views of the Basic Law Committee. And Ms. Elsie Leung is the Deputy Director there. She's stating her views, and it caused an uproar in the community. Ms. Elsie Leung is no stranger here. She was in charge of the Article 23, and she was responsible for the Sally Orr case. I think it is only right for her to explain herself at this platform. I think she's an honest person. I mean, she doesn't practice sophistry as does the Chief Executive, Mr. C.Y. Leung. I think it's only right for her to tell us how she thinks in her capacity. I do respect her. I'm not really trying to put her through public trial. I would like to look forward to hearing from her explanation. and let people who cast doubt on her remarks have a clear explanation straight from the horse's mouth. Now, she said that if the court understands the relationship between with the central government, then all these mistakes will not have been made. Is it true that the CFA will have to consult the NPCSC before a decision should be taken? Or does the court have to understand one country first before talking about two systems? I hope that Ms. Leung would come before us and explain herself. Mr. Leung, will you direct the question to the representatives? Well, I look forward to the speech delivered by Mr. Rimsky-Yuen. Mr. Dennis Kwok. In paragraph 7 of her statement, Ms. Elsa Leung mentioned Article 17 of the Basic Law. Mr. Zhang Xiaoming of the Hong Kong Macau's Affairs Office wrote an article enriching the one country, two systems, and so on. He also mentioned this. He said that to make sure that there is a system of reporting to the NPCSC regarding the laws enacted, and also to monitor the situation, and so on. All these remarks are making us very worried. Is it the case that somebody is trying to tighten up on the legislative power in Hong Kong, or the one country, two systems? I'd like the SJ to tell us in relation to Article 17 of the Basic Law, and does he agree that under this article there is something that has to be done, something that has to be implemented in this context? SJ. Madam Chair, Mr. Kwok, Article 17 of the Basic Law is very, very clear. Let me say this. There is a mention that Hong Kong SAR should be vested with legislative power. Laws enacted by the legislature of the Hong Kong SAR must be reported to the NPCSC for the record. I repeat, for the record. Now, the reporting for the record shall not affect the entry into force of such laws. And it goes on to say that if there are any inconsistencies, the law will be returned, but it will not amend it. So the provision is very, very clear here. I can tell members that since 1997 through to now, there have been 551 pieces of legislation that were submitted or reported to the NPCSC for the record. None of them have been returned. Mr. Kwok mentioned Mr. Zhang Xiaoming and his article. My understanding is that this article was lifted out of a book. It is not an article written for any particular newspapers in Hong Kong. Our view is that all laws enacted by the legislature in Hong Kong will have to be handled in accordance with Article 17 of the Basic Law. Mr. Kwok, so the SJ agrees that there is nothing that has not been implemented that should be implemented. What has to be done has been done. Do you agree with that, SJ? Since July 1st, 1997, 551 pieces of legislation were reported. None of them have been returned. Now, as to whether there are other areas that for which improvement can be made, I'm sure that everything can be discussed. Now, you talked about improvement. I think every improvement has to be made in accordance with Article 17. It is only on the condition that Article 17 is not breached that improvement can be made. I mean, as to whether there are any improvements to be made, it's hard to say. Any system can be improved, but any improvements that may have to be done in accordance with Article 17 of the Basic Law. under 159 of the Basic Law, any amendments will have to be done in accordance with the Basic Law and also the one country, two systems principles. Any changes or otherwise would have to be done in accordance with the Basic Law and one country, two systems. Mr. Ronnie Tong. Madam Chair, what is most controversial about Ms. Elsie Leung's remarks is in the case of Ng Ka-ling's case, if the judges understand the relationship between the SAR and the central government, then they would not have made the mistakes. So the judges in adjudicating cases in relation to relationship between Hong Kong and the mainland, would the SJ agree with Ms. Elsie Leung that she's carrying a lot of weight, and I'm wondering whether she has to clarify these doubts. I mean, why didn't the SJ clarify these misconceptions there and then?
In our paper submitted to the LegCo, we did mention that on the 7th of October, we issued a statement after attending the legal week of the Law Society. I did air my views upon inquiry by the media. As for the issuance of a statement, our position is that if the speech given by anyone doesn't contravene the Basic Law, we do not need to make a statement every time. Well, Secretary, but she made a very high-profile response to Mr. Alan Hu's remark. Whether Ms. Elsie Leung's remarks have contravened the Basic Law, she was being disrespectful for the judges in Hong Kong, and her remarks infringed upon the independence of judges in their adjudication. So shouldn't the Secretary hold a similar stance in responding to Ms. Elsie Leung's remarks? Secretary. Well, like I said in the opening address, we may have different views on the implementation of one country, two system. But as Secretary for Justice, what we consider is whether those remarks are in contravention of a particular provision in the Basic Law. Well, Secretary, I won't argue with you, but do you agree with me that, or are you agree with this statement that the SAR judges should understand the relationship with the Central People's Government as Secretary of Justice? So what is your personal view? Do you feel that our judges have to be familiar with the mainland before they can adjudicate cases, or they will make wrong judgments? Don't talk about Ms. Elsie Leung, just talk about yourself. Madam Chair. Now, during the implementation of one country, two system, we may have different views on the same matter. Someone might think it's correct, someone might think it's not. As Secretary for Justice, I don't think I should discuss a particular view of a particular division or of an individual. Please queue up for the second round if you want to follow up. Mr. Alan Leung. First of all, I thank the two representatives of the Bar Association and the Law Society for attending this meeting. And I agree with Chairman of the Bar Association that if we have heard some remarks which might question the rights safeguarded by the Basic Law, then we should, at the first opportunity, make clarifications in a solemn manner. During the Article 23 legislation, the chairman of the Bar Association, this comment of frogs boiling in tepid water was made. If anyone wanted to challenge the legal system in Hong Kong, and if we do not speak up, then we will become boiled frogs. So it's very important that we take a serious stance on Ms. Elsie Leung's remarks. And on behalf of the Civic Party, I do not agree with Ms. Elsie Leung's approach in sending a letter to this panel on the 20th of November, stating that she refused to attend this meeting as she was afraid that this meeting would turn into a McCarthy hearing. The McCarthy hearing was about the communists in the United States being subject to oppression or persecution. If your organization was believed to be related to communists, your organization would be replaced, and if you were suspected of being a communist, you would be sacked by the government. Now, Ms. Elsie Leung said that her freedom of speech is being infringed upon, but has she been sent to prison like Mr. Liu Xiaobo? No, we just said that since she holds this position, she should be given this chance, and we should also be given this right of freedom. This should be balanced. So the justifications put forward by Ms. Elsie Leung could not stand on their own feet. A successful implementation of the one country, two system is important. It's unprecedented. If there is only absolute power, then definitely the one country, two system will not succeed. All right, this is a comment, or this is for the record. I have to put this on record for clarification. I have said on an open occasion, on an occasion that this is not a McCarthy hearing. We're just inviting representatives holding a high position to attend this meeting to clarify matters, and very often this is the approach we take. The next member, Ms. Emily Lau.
First of all, I would like to thank the representatives from the Bar and the Law Society for attending our meeting. And I also regret very much that Ms. Elsie Leung has chosen not to attend. And the reason we have invited her is that she has made some very alarming remarks which we think undermine one country, two system and the core values of Hong Kong. So even though she's not here, I hope that we will have an opportunity to meet her in the not too distant future to tell her directly how we feel, how the Democratic Party feels, and how many Hong Kong people feel threatened by her remarks, given her status and her office. Madam Chair, I want to ask the representative of the Bar and the Law Society a question. I refer to the paper submitted by the Bar, the last part of paragraph 5, in which it says, any public act which undermines the authority of the Hong Kong judiciary is likely to be perceived to be a threat to the rule of law and the independence of the judiciary, even if the public act is otherwise permitted by the law. So I want to ask them whether they regard the remarks by Ms. Leung as a threat. And also, if I may refer to paragraph 9 of Ms. Elsie Leung's statement, in which she said, I do not know what gave him being Justice Bokhari, the cause of alarm for saying that clouds heralding a storm of unprecedented ferocity are gathering over the rule of law in Hong Kong. Does the Bar and the Law Society agree with Mr. Bokhari's remark? And do you think the Secretary for Justice has done enough to defend the rule of law in Hong Kong? Thank you.
Mr. Ramanathan and Mr. Thomas So.
What we were referring to in paragraph 5 was not to any specific act as such, which could be interpreted in one way or the other. I think the point that we were trying to make really is if persons in their belief that they're exercising their power of free speech, but because of the position they hold, speak on occasions where their position carries a weight much more than an ordinary person in the street does. And those statements can be interpreted as an undermining of the independence of the judiciary. That is to be regretted. And that is what we were directing that particular part to. Because it's difficult to generalize what act specifically would necessarily undermine it, because it would depend on the individual circumstances. But we were more concerned to ensure that you do not, or not just one individual, even an organization, does not use the right of free speech, free expression, as a platform to then undermine the very rights that they seem to be exercising themselves, but prevent others from exercising for themselves. And that will be the slippery road in terms of undermining the rule of law. Turning to your second question, as to the comments of Ms. Leong in relation to the statement by Mr. Justice Bukhari. I think the two comments have to be looked at in context. Each one is commenting, as I see it, on the views expressed by the other. And whether the one be right or the other be wrong, I don't think the bar would like to waddle into that area to say who's right and who's wrong. There are two different perspectives. Mr. Justice Bukhari takes a certain view of the statements made, and Ms. Leong seems to take a different view. We as the bar, as the professional body, we look at the statements made in general to see what impact and effect it has in terms of the rule of law and in terms of the independence of the judiciary. And I think we leave it, as we always have, for the public to decide where the right or wrongness of the issue lies.
Thank you, Mr. So.
Responding to the first point, the Law Society's position is in principle in line with what the bar has said. As we said in our statement, we are not there to prevent anyone from exercising their right of freedom of speech. But then in this particular instance, it is the public perception that Ms. Elsie Leung's comment has given rise to the perception that because of her occupation, of her background, she ought to be more careful with what she said. And responding to the second point, the Law Society, I think, is not in a position to comment on individual comment made by people, including Ms. Leung or Judge Bukhari. But we feel that the court is functioning well, and that including the bar and the Law Society, we have been doing our best to arouse public awareness of the importance of maintaining the independence of the judiciary.
好，跟住係譚耀宗議員。
Next, Mr. Tam Yo-chung. Madam Chair, today, well, you said that you've written to Ms. Elsie Leung, inviting her to come to this meeting, and she declined, and we should respect her decision. I don't think, personally, that she should come, but I'd like to thank her for submitting a very detailed statement explaining the background of her remarks. Having read the statement, I don't see any problem at all. And the background is that she took part in a pro bono talk She gave a pro bono talk on the invitation by an education institution on the legal challenges since reunification. In fact, she had made those remarks on various occasions before. So under the principle of freedom of speech, she should not be questioned. Mr. Alan Leung talked about handling the issue in a solemn manner, and I was really surprised. I don't know what he means. And I don't think that she should face such allegations or criticisms. Of course, we have freedom of speech in Hong Kong. You can express yourself. Other people can express themselves as well. There is no problem. As to whether her remarks were made on behalf of the Basic Law Committee, she already clarified it. The Basic Law Committee is an advisory body. Although she is the Deputy Director, the committee is actually taking up a passive role as far as advice is concerned. The committee only performs the role as stipulated by the terms of reference. So she is not speaking on behalf of the Basic Law Committee or the NTCSC. So this matter should not be magnified. And on the points about judicial independence and the rule of law, I don't think they're relevant. Many judges have already expressed that the judicial independence will not be affected just because of the remarks made by some people in the community. Our judges will not be affected easily, and that includes Mr. Justice Bukhari. So if you talk about criticisms on the law, on the courts of Hong Kong, then this happens all the time. Sometimes public figures may not be happy with the judgments of the CFA, and they very often pass on criticisms. And this happens in other countries as well.
Well, this is no big deal, really. When you look at the Ms. Elsie Leung's remarks, she's basically airing her feelings about the situation. Right? This is a comment, and let's move on to Mr. Martin Lau. Madam Chair, thank you. Regarding Ms. Elsie Leung's remarks, I can't see anything that has undermined the rule of law. These are what she said during the 2-hour talk, and she's only stating her perspective. Mr. Leung Kwok-hong made the remark a moment ago that those who know Ms. Elsie Leung know that Ms. Elsie Leung is a straightforward person. She's telling like it is, and I don't think this has interfered with the rule of law. People may hold different views. Just because there are bias doesn't mean that we have to take her remarks too far. Mr. Justice Bukhari made the remarks.
Everyone is entitled to her own views and the freedom of speech, and other members of society are free to agree or disagree.
Also, the Bar Association's Submission Power 7 also mentioned the importance of freedom of expression. I think all these showed in a pluralistic society like Hong Kong, we should respect the freedom of expression. And I agree with the Bar Association and Mr. Justice Bukhari. If I may put a question to Mr. Ho, the Law Society, in the Lau Kong Yung case, the CFA made it clear that the interpretation of the Basic Law derives from the Chinese Constitution, and this power is comprehensive and will be unfettered. Do you think that this judgment is a part of Hong Kong's rule of law? And also, do you think that this judgment by the CFA has undermined the Constitution in Hong Kong? Well, this is the judgment is a part of Hong Kong's system. There is some mention of the mainland issues. Under the Basic Law, there is some room. Article 158, if you notice that the CFA in adjudicating cases derives its power from the NPCSC to interpret the Basic Law. And it mentions that the NPCSC is vested with the power to interpret the Basic Law. Now, under what circumstances can it interpret the Basic Law? Well, I'm talking about the Lau Kong Yong case. Is that the power of the NPCSC is comprehensive and unfettered. Well, the Law Society agrees with that. Now, previously, we've also mentioned that before. Ms. Darili. Madam Chair, thank you. I also respect Ms. Elsie Leung's decision not to come to LegCo to discuss her remarks. Now, we all quoted from her letter. There is one point that hasn't been quoted. She's made it very clear, and she said that if people have doubts about her remarks and would like to interact with her, they can make an appointment with her at a mutually convenient time and place. And she just feels that LegCo is not the right forum for her to do so. Now, I think we have to be fair to Ms. Elsie Leung. It's not the case that she doesn't want to discuss her remarks. It's just that LegCo is not the right place. If members would like to have a word with Ms. Elsie Leung, you may wish to act on her remarks and make an appointment with her. I also agree with her as to whether LegCo is the right place to discuss the politician or some celebrities' remarks. I am a member of the Public Accounts Committee. Now, even if PAC were to invite people to attend the PAC meetings, people outside the government will have to be very, very careful, because we are here to monitor the government departments. I sat on the PAC for the past 4 years, and we didn't see the need to invite anybody outside the government unless that person would like to do so on a voluntary basis. Now, this is a panel, and I don't think we should insist on having Ms. Elsie Leung here to explain herself. I think our terms of reference is very clear. We are monitoring and study all the policy matters to do with legislation and so on, including the responsibilities of government officials and exchange views with the administration. Regarding the remarks by certain political figures, it's a different matter altogether. There are other more important issues to handle. I think we have to respect the decision or choice of Ms. Elsie Leung. Those who are interested in exchanging views with her can make an appointment with her. Also, I agree with some other members that her remarks will not undermine the independence of our judiciary, because the judges are of high caliber. People of different backgrounds very often express their views. If you were to say that these remarks would undermine the independence of the judiciary, then I think this conclusion would be a rash conclusion. Right, that's by way of remark. Mr. Ng Leung Sing. Madam Chair, thank you. My observation is that if you set a precedent today, if anybody... Now, Ms. Elsie Leung is a resident in Hong Kong. She plays a constitutional role, and we do have CPPCC members or NPC members. We may have among us members from certain international organizations. Now, they may not be constitutional bodies, but they may be they may be playing some role which is influential. Now, there might be people with close affiliation with Beijing. I mean, if you're not pro-Beijing, who are you pro-US or pro-UK or what? I think even if you're talking about CEPA, it is a close partnership with the mainland. The business sector would like to have closer association with the mainland for obvious business reason, commercial reason. If somebody were to say something and we invite them to come here, then would we be setting a precedent of clamming people up, and people, if we set this precedent and if certain remarks are not music to our ear, then people would be shutting up. And I hope that members would pay particular attention to this point. Under the Basic Law, Article 27 of the Basic Law, every citizen in Hong Kong, even those without 3 stars on their ID cards, will enjoy this right of freedom of expression. If I may put a question here. Now, these political figures that I referred to, should there be any guidelines for these people regarding their remarks, in order that their remarks will not undermine the rule of law? If there are certain members who have other capacities, should they follow these guidelines? From reports, I learned that some judges mentioned certain things. Should we do something about them in order not to cause any concerns in the international community? Right, anybody can respond. Mr. Ng raised these questions. Whoever is interested can follow up. Mr. Paul Chair. Madam Chair, 2 questions, if I may. Well, I, to a certain extent, go along with Mr. Alan Leung about this idea of a frog being boiled in warm water, and you're turning up the temperature gradually. And I think we have to guard against this syndrome. Article 1 of the Basic Law says that the Hong Kong SAR is an inalienable part of the People's Republic of China. There are some remarks that certain people are waving the colonial flag, and people are reminiscent of the colonial rule. Now, if we do not challenge that, would there be any frog boiling syndrome? And also the Bar Association, Ms. Emily Lau quoted the Bar Association that any public acts that would undermine the independence of the rule of law, then it would be a threat. If I may put this to the chairman of the Bar Association, or anybody for that matter, there are some colleagues or some members of the public. Now, Mr. Wong Yuk Man mentioned a moment ago that he criticized the judges and so on. Now, for these remarks, will they be more damaging to the independence of the judiciary, or would Ms. Elsie Leung's remarks be more damaging to the rule of law? Mr. Remanathan.
I was not present when Mr. Wong Yuk Man made those statements, but leaving that aside, I'm not here to, and I don't think it would be right for me to make a comparison between what will amount or what will not amount to an attack on the judiciary or undermining the independence. I think the point which I think needs to be made and to be got across is simply this. It's one thing to say that I do not like this judgment, I disagree with it. That's a personal view. But when you have a position in society, a very high position in society which carries and wields considerable power and influence. And then you make a statement, an extrajudicial statement, which suggests the judiciary is out of touch with the law that they have been tasked to administer in terms of interpreting the law. That is quite a different situation to the scenario that you have of Mr. Wong questioning or not agreeing with views of certain judges. I think they're quite different situations, and one has got to be careful. We're not comparing apples and oranges, and I think that's what we'll be doing here. But I think it will depend on the circumstances, and it's the circumstances in this particular case that made the bar feel that it had to come out and make a statement to assist the public to understand what is the debate which is taking place. Thank you.
Anything to supplement, Mr. Paul Chair? I want to supplement, but I don't have any time. But please queue up for the second round, Mr. Wong Yuk-man. I won't respond to Paul. Well, he is definitely going to gain political mileage. I won't be imprisoned. I won't be sent to jail. Well, members who are with me in this room do not share the same view with me. Starting from day one, I have never believed in one country, two system. I have maintained the same stance throughout. But some people are sometimes naive, sometimes too simple. Some councils think that they can safeguard the one country, two system, including the two legal professional bodies. But this Hong Kong SAR is under the rule of the China Communist Party. So this basic law is, and the one country, two system is nothing but crap. Well, the law is evolving, is developing together with the society, well, so on and so forth. Well, just read the history. Do you really believe that there is Hong Kong people ruling Hong Kong and the rule of law? Ms. Elsie Leung's remarks, well, she has been making those kind of remarks even when she was the Secretary for Justice. Well, this Mr. Yuan, Secretary for Justice, sometimes he says that the basic law should be safeguarded, but sometimes he dare not say anything that will anger the Communist Party. Well, it's set out very clearly that when the Court of Final Appeal, before making final adjudication for matters that related to the CPG, may seek interpretation from the MPCSC. But there have only been 4 occasions when we had interpretation. So everything is about political interference. So let's not be naive. We have this item on the agenda so that we can just express our views. Just like the DAB, the founder of an organization is Ms. Elsie Leung, so definitely the DAB supporter. So it's just like Anderson's fairy tale. We're just a young kid in the tale. That's what happened in the so-called referendum of the five constituencies, and then we faced all sorts of criticisms and oppression. This is the Hong Kong SAR under the rule of the Communist Party. Be it the rule of law and the human rights, we are subject to a lot of threats, and we must fight our way till the end. We have no alternative. If you think that they are kind and China is changing, well, if you want to believe that, I can't do anything. Well, you can't ask Ms. Elsie Leung not to make such remarks, so on and so forth. Definitely, one country, two system is bankrupt, and the basic law is crap, and that's it. Next, Mr. James Toh. Madam Chair, I'd like to ask Secretary for Justice this question, and it's actually the same question asked by Mr. Ronnie Tong. I'm not asking you to say whether it's right for Ms. Elsie Leung to have made such remarks. But in her statement, or in her remarks, she said that the judges should be familiar with the relationship between the CPG and the Hong Kong SAR before they could judge or adjudicate on any case, and this is very serious. Just now, Secretary for Justice was asked twice this question, and he chose not to comment on it. Well, I'm giving you this one more chance. I'm giving you this opportunity. I will be stopping soon so that you have ample time to respond. If you have no view on this matter, or if you think that there is no need to safeguard the rule of law in Hong Kong by expressing your view on this matter, I think this record is very important. This record is a test to let us know whether Secretary will safeguard the rule of law during critical moments. I wish to repeat Mr. Ronnie Tong's question and give you another opportunity for you to answer this question. Of course, I won't reprimand you if you don't take this question, but this will give us an impression what sort of person you are. Secretary. Just like what I've said to the media, and also as I said in the opening address, as Secretary for Justice, I can guarantee to the general public that we will safeguard the legal system in Hong Kong, the rule of law in Hong Kong. We have never changed our position. And I want to reiterate my position today again. Whether my position will be changed based on the decision whether to comment on an individual's remarks or not, I can say that it's not the case. This will not change my position in safeguarding the rule of law and judicial independence in Hong Kong. As to whether judges in Hong Kong should familiarize themselves with the relationship with the CPG, I reiterate that I will not comment on remarks made by an individual in a particular circumstance. On the selection of judges, we have a healthy mechanism, and we should trust this mechanism. Secondly, be it before 1997 or after 1997 or 15 years after reunification in 1997, the judiciary in Hong Kong has been very intact, and we must have confidence in our judges, including judges of the CFA. Next, Mr. Michael Tien. Thank you, Madam Chair. I'd like to look at this issue from various perspectives today. First, on the knowledge that our judges should have. Well, some say that under the one country, two systems in Hong Kong, our judges should know both the common law system and the laws of the mainland, because we are under one country, two system. And some say that judicial independence means that they should only pay regard to one system and not matters related to the PRC, like the basic law and interpretation of the basic law. I have an MBA degree. I don't have an LLB degree. So I don't know who's right, who's wrong. So I dare not comment on it. But the point is, have Elsie Leung's remarks exerted any pressure on the courts of Hong Kong? Ms. Elsie Leung explained that in Chong Fung Yun's case, the Court of Final Appeal failed to consider the comments raised by NPCSC, and she said that how would the comments affect the court's ruling? Well, basically, the comments this seems reasonable. Now, I'd like to ask Mr. Ramanathan representing the Bar Association.
Share with me your response. Do you think, or does the Bar think, that the judiciary's future rulings will be influenced by Ms. Leung's statement? It's a very simple question.
It's a simple question, but I don't think the answer is easy, because we have never said that her statement per se will necessarily influence the judiciary. It's the perception that statements like that coming from a person of certain authority could be perceived as an attempt at interference. That's the point which is being made.
Okay, thank you. 嗱，我嘅直接演繹呢，就係
Well, my direct interpretation is that he's not sure. It's not sure whether it will exert any influence in the judgments. And thirdly, I agree with Mr. Alan Leung, and for those criticizing her, saying that she's wrong, they should also enjoy freedom of expression. So there's no problem. We just agree to disagree. In fact, this is not a legal issue. This is a political issue. Whether Ms. Elsie Leung decided to come to this meeting or not, this is a political issue. She has thoroughly considered the issue, and this is a political consequence that she has to bear, and this is a political right enjoyed by her. I don't think we should the right to stop her from doing that. I think she has the right to make this decision. Mr. Chan Kin Po.
出對個人嘅意見呢，其實我哋可唔可以有個睇法呢？就係話
Well, I think that since she has studied the correlations between the English law, the UK law, the Hong Kong law, and the PRC law, and made such reminders, we should not be so alarmed. And the judges are protected by the system in Hong Kong, and we should respect the caliber of judges and the conduct of judges. I don't think that they can be easily influenced by others. I should, on the other hand, say that we should review our position in this chamber. Why are we scaremongering the public? Why are we always launching attacks on an individual rather than commenting fairly on an incident? I think we should be fair. I need to inform colleagues that it's now 6:25. I have the discretion to extend the meeting by 15 minutes. And we still have Mr. Albert Ho and 3 other members waiting in the second round. So I'll only allow 1 minute for each member in the second round. Mr. Albert Ho. Madam Chair. Many members ask why we're getting so anxious, because Ms. Elsie Leung was only making the remarks in her own capacity. But let us look at the substance of the remarks. She said that in Nkaling's case, she said that there was insufficient understanding of the relationship between the CPG and the Hong Kong SAR by the judges in Hong Kong. She was not talking about the judgment or the reasoning in the judgment itself. She just made the simple remark. She said that there was a lack of sufficient understanding of this simple matter, and they should re-educate themselves. And on the issue of pregnant mainland women giving birth in Hong Kong, she said that the Hong Kong SAR government should seek interpretation of the basic law by the NPCSC. In 1999, after Nkaling's case, many people felt that interpretation or the meaning of the law should only be amended through amending the legislation. To seek interpretation of the basic law by the NPCSC, this will affect the position of the CFA. I recall that I was attending the ICSCR meeting, and this was about socio-economic rights, and I faced a lot of questions. They ask, well, if the Hong Kong government is taking an initiative to seek interpretation of the law, then will there be any one country, two systems left in Hong Kong? Now, she is the Deputy Director of the Basic Law Committee. She is responsible for interpretation of the Basic Law and offering advice to the NPCSC. So she is in a high position, and her remarks carried weight, and therefore her remarks were published in the newspapers. This is so-called influence. Hong Kong people have a great sense of history. During the Cultural Revolution, there was a play called the removal of office of one of the officials. Well, but things were not was not this simple. Mr. Allen is right. We should hold firm our positions. We should safeguard the rule of law and the judicial independence. This is what we can do today.
Ronnie Chong, Leung Kwok Hong, and Paul Che, I draw a line there. Ms. En Chung, first round. We are running out of time. 2 minutes for you, please. Shouldn't I get 3 minutes? I request 3 minutes. I'll make it quick, please. Madam Joan. I am pleased today. Last time I sat here, I said that Ms. Elsie Leung's remarks should be protected by freedom of expression. And Mr. Wong Yok Man jumped on me and said that I advanced warped arguments. Ms. Claudia Mo said that freedom of speech doesn't mean that everybody should be equal. I'm pleased to hear from the legal professions that Ms. Elsie Leung should enjoy freedom of expression, and Justice Bukhari also confirmed that Ms. Elsie Leung should enjoy freedom of expression. I've got some friends who supported me, and they're telling me that the UN declaration made it very clear that everybody should enjoy freedoms and freedom of expression, whatever the origin or the status, they should enjoy freedom of expression. I would like to put a question to Mr. Remenathan, SC. Now, the Basic Law talks about 50 years of no change. And basically, we're talking about the way of life under the capitalist system will remain unchanged. Now, we have to move on with times, and we have to be in line with the world, and we have to make changes continuously. For instance, electoral members are here to amend, enact, and rescind and repeal certain pieces of legislation or provisions. So I must make it very clear that I am staunchly supporting independence of the judiciary. But I believe that the friends of the legal profession should ask themselves, is the judiciary or the legal system in Hong Kong flawless? Should we do something to improve the existing judiciary system? I don't think it's right for us to say that we can't even talk about it. I mean, we shouldn't say that this is off limit to anybody. The mere fact that we talk about the judiciary would mean that we're trampling upon the judiciary, and like Mr. Alan Leung said, the moment we start talking about the judiciary system would be equated with the boiling frog syndrome. And I think that we should be full and frank, and we should be honest and talk about it on the basis that we uphold our freedom of expression and also uphold the independence of the judiciary. We can talk about this in a frank and full manner, although this doesn't have to take place here in this Legislative Council, because we do have a lot of other things to do. Mr. Remanathan, would you like to respond in brief, please, for 4 other members?
Madam Chair, I'll just respond very shortly. As far as the bar sees it, there's nothing wrong with having an informed and open debate about the quality and system of justice we have in Hong Kong. Obviously, no system of justice is perfect. It always has to go through changes. It's got to be improving. That's the reason why in 2009 we had the civil justice reform to upgrade the civil justice of judiciary and the civil justice of civil actions. At the same time, what I think is promised in the basic law is that the legal system, not the laws will change because the legislature and the public, with changing times, will require different legislation to meet the challenges of the day. That's quite a different issue from changing the legal system. Our legal system prior to 1997 and as enshrined in the basic law promises us 50 years of that same thing continuing with the changes which will be coming through the legislature and as part and parcel of the constitutional development under the basic law as well. But it's quite a different thing to have new laws change circumstances, but quite a different thing to say you want to change the entire legal system. And I think that is where the bar, and for that matter the legislature, should be careful about.
Right, I think we have to move on to the second round. We can discuss further on other occasions. 1 minute, Mr. Ronnie Tong. I'd like to ask the SJ, the freedom of speech and also the right to stage rally and demonstration. They are not absolute, they can be regulated. Freedom of speech, they can be libels. The Wong Yung case shows that libeling the court, being defamatory to the court is an offence. I mean, can the SJ confirm this? SJ? Madam Chair, Mr. Ronnie Tong, from the legal point of view, freedom of speech is regulated by law. Now, there can be a number of aspects. One of them is, like Mr. Ronnie Tong said, the defamation is one facet. The other thing is that when a litigation is going on, if there are any remarks that would constitute an insult, a contempt of court, that would be another thing. What about the Wong Yung case? Have you read about this case, the CFA judgment? SJ, if you haven't read it, I would advise that you read it. Well, you might wish to discuss these cases on other occasions. Mr. Leung Kwok Hong. Well, I find what Ms. An Zheng said really hilarious. Now, are you defending the freedom of speech by Liu Xiaobo? What he said and landed him in jail for 11 years. Ms. Elsie Leung constitutionally has the right to reflect, has the right to air her views to the NPCSC. We're asking her to come before us. Now, when interpretation of the basic law takes place, the NPCSC has to consult her views. Also, Ms. Elsie Leung said that this is going to be a McCarthy hearing. This is nonsense. McCarthy is a politician. He has a committee subpoenaing all these people. If they don't come along, they will be in jail. Do we have this power? Now, if I believe they ask you whether you're a Communist Party member, if you don't answer this question, you'll be in jail. Do you defend the freedom of speech of Mr. Liu Xiaobo? Mr. Porche? Madam Chair, were any national issues or or understanding of love relationship or romance, whatever, all these understanding would help the judges to adjudicate a case, not just the national affairs. Also, the Inkaling case, and also after Lau Kong-yong case, the interpretation is wider under Article 158. I think instead of just reading the Inkaling case, I think you should also read about the Lau Kong-yong case. Third, now when it comes to the interpretation of the basic law, I don't think we should merely talk about the common law. We should also look at the continental law. Ms. Elsie Leung is merely saying that the judiciary or the lawyers should not just understand the common law, but also the continental law, and that's only right. Mr. Dennis Kwok. Madam Chair. Now, members are saying that she's merely saying it. We don't really have to be overly alarmed about it. Now, I must tell members that in the international community, in the legal fraternity, if you look on the web, there are so many comments, so many discussions going on about Ms. Elsie Leung's remarks and the implications and on the judiciary and legal system in Hong Kong. It's not just about freedom of speech. In fact, the legal profession from overseas jurisdiction also asked me about her remarks because they don't follow Hong Kong's situation all that closely. Her remarks would give rise to doubts as to whether this would undermine Hong Kong's legal system. As in Hong Kong, as a cosmopolitan city, it's not just about freedom of speech. Now, that's the reason why the Law Society, the Bar Association, issued these statements in defense of the freedom, the judiciary. Right? SJ and other representatives, if you wish to respond, please do. SJ. I'd like to pick up on the question raised by Mr. Ron Lee Tong. I didn't quite finish with my reply. I'd like to say that at this point in time, I haven't seen or haven't heard anybody who said that Ms. Elsie Leung's remarks constitute defamation against the judges, or what she said exceeded her freedom of speech or against the law. All right, thank you very much, SJ. Yes, representatives?
Briefly, I'll remind members of paragraph 5 of our submission and what we say the public are entitled to look at. And I'll repeat this. The public in Hong Kong are accustomed to and are justifiably confident in a system whereby legal disputes and questions of legal interpretation are 1, resolved in courts that are independent from political influence, 2, which hear cases openly and fairly, 3, upon receiving evidence presented by both sides to a dispute, and by reference to well-established legal principles, as well as legal materials placed before them by the parties, and which are freely and openly accessible. I emphasize this to underscore the point. It is not a question of the judiciary trying to understand what the system in the mainland is. They can only decide cases on the materials that the parties place before the court. They can't go behind in their chambers to do internet research to find out what the system in China is or anywhere else. It's for the parties to place the relevant materials before them, and so based on those materials, which are legally admissible, that the judges can decide.
I'm so, nothing to add. All right then, my thanks to all the representatives for being with us. We've heard diverse views, and I'm sure that this is not the last we've heard of this subject. There are other forums on which this issue will be discussed. Thank you all very much for coming. The next meeting is scheduled on the 14th of December. I look forward to your presence. Thank you.